Industrial Disputes Act, 1947, Scope, Object, Main Features, and Important Definitions. Scope. The Industrial Disputes Act, 1947, IDA, is a central legislation applicable to the whole of India. It regulates the investigation and settlement of industrial disputes between employers and employees and promotes industrial peace and harmony. The Act applies to all industries, including factories, mines, plantations, transport services, and banking and insurance companies. Objects. The main objectives of the Industrial Disputes Act are to provide a mechanism for the investigation and settlement of industrial disputes, to prevent strikes and lockouts, to promote industrial peace and harmony, to protect the interests of workers and employers, to secure social justice for workers. Main features. Some of the important features of the Industrial Disputes Act include Works Committees. The Act provides for the establishment of works committees in industrial establishments employing 100 or more workers. These committees are composed of representatives of employers and employees, and they discuss matters of common interest. Conciliation Officers. The Act appoints conciliation officers to investigate industrial disputes and attempt to settle them through conciliation. Industrial Tribunals. If conciliation fails, the industrial dispute is referred to an industrial tribunal for adjudication. The tribunal examines the dispute and gives an award, which is binding on both the parties. National Tribunals. The Act also provides for the establishment of national tribunals to adjudicate industrial disputes of national importance. Prohibition of strikes and lockouts. The Act prohibits strikes and lockouts during the pendency of conciliation proceedings and adjudication. Layoff and retrenchment. The Act regulates the layoff and retrenchment of workers. Unfair labor practices. The Act defines and prohibits certain unfair labor practices by both employers and employees. Important definitions. Some of the important definitions in the Industrial Disputes Act include Industrial dispute, any dispute or difference between employers and employees, or between employers and workmen, or between workmen and workmen, which is connected with the employment or non-employment of any person. Workman, any person employed in any industry to do any skilled or unskilled manual, supervisory, technical, or clerical work for hire or reward, whether the terms of employment are express or implied. Employer, the owner of an industrial establishment, any person who has ultimate control over the affairs of an industrial establishment, or any person who is responsible for the supervision and control of employees in an industrial establishment. Trade union, any combination of workmen or employers formed primarily for the purpose of regulating the relations between workmen and employers, or between workmen and workmen, or between employers and employers, or for imposing restrictive conditions on the conduct of any trade or business, and includes any federation of two or more trade unions. Strike, a cessation of work by a body of persons employed in any industry acting in combination, or a concerted refusal, or a refusal under a common understanding of any number of persons employed in any industry to continue to work. Lockout, the closing of a place of employment, or the suspension of work, or the refusal by an employer to continue to employ any number of persons employed by him. Note, this is a brief overview of the Industrial Disputes Act, 1947. The Act is a complex piece of legislation, and it is recommended that you consult with a legal professional for any specific advice or interpretation.